7:39 is our time here on Sky 99.5 FM, and it's time for us to do some more news making here on the Breakfast Roundtable. On the line with us, Martin George, a senior attorney at law and member of the Police Service Commission. Good morning to you, Martin George.
Hi, good morning to you, Jesse.
Good morning, Mr. George.
Good morning, Edison.
Yes, Martin George, we want to take a look at these corruption cases that have been filed by the Attorney General. They were filed last week, and there has been silence, as it were, with regard to these cases. They're being very, very cagey and tight-lipped in terms of who exactly is involved and even what is involved in prosecuting these cases. Anyone looking at it would think that they're doing their best to ensure there isn't too much negative publicity so that could be used as a technicality to have the cases thrown out. And also, they're trying to ensure there are no leakages in terms of the strategy to be employed in the prosecution.
Well, Jessica, maybe the Attorney General is attempting to be a lot more cautious and circumspect than the FBI director in the U.S.
Wow.
Realize that he has been the main source of all the controversy around the election, including his announcement yesterday, where he basically sought to dig himself out of the hole that he dug for himself 9 days ago with his announcement concerning the emails. So maybe our Attorney General has looked at that scenario in the U.S. and decided, look, he's going to be a little bit smarter than the FBI director, and not go, talking too much and speaking out of turn. Now, the thing is, there's a flip side to it, though, in that if it is that these are cases which are filed in the civil jurisdiction of the High Court, then any document or any matter such as that is actually a matter of public record. So there are two things. The media is entitled to go to the civil registry and file a request for copies of the documents that have been filed, or even any member of the public is similarly entitled, because these are matters of public record. So there's no question. I saw people speaking in the newspapers on the weekend, bandying about terms about sealed indictment and that kind of thing. These things, first of all, these things don't apply in Trinidad and Tobago. We don't use that term in a sense, right? And certainly not in a civil matter. There's no question of there being a sealed indictment in a civil matter. A civil matter is filed in the civil registry of the High Court. So the thing is, if it is that it is a civil matter that has been filed, then it really is a matter of public record, and one way or the other, the information will come out. So we certainly applaud the Attorney General for taking, I guess, a more restrained approach rather than trying to politicize the issue, and rather than trying to make it a campaign, platform. So that I certainly admire and respect, because you would have seen in previous, office holders, who occupied that chair of Attorney General, some have sought to use this opportunity as, basically to launch a political attack, and to use this type of litigation to make it us against them, so to speak, from on the political landscape. And that I don't think is proper. I've always said the role of Attorney General is that you are Attorney General for all of Trinidad and Tobago, and I certainly would say that I admire the restraint that the current Attorney General has shown, in terms of matters such as this, not seeking to get cheap publicity of the major national issues. So that part I respect, but I would also say that if it is a civil matter, a matter filed in the civil registry, then certainly in terms of the names and the details, that will come out anyhow. So there's no real question to say that, it's going to be kept a secret for very long.
Now, it's a civil matter that has been launched, but surely during their investigations, they may have come across evidence for criminal matters to be prosecuted. And which should really come first? Should you not do the criminal matter first rather than the civil matter? Is it that he felt he would have had a better chance at prosecution going the civil route, that it would have been harder to prove criminal matters. What sort, how do they make that kind of determination based on the evidence that's brought before them?
Well, unfortunately, yes, we're all speaking in a vacuum, and, it's all basically speculative because, first of all, we don't know the details. So I don't even know that, there were criminal aspects arising, and in which case that becomes now the preserve of the DPP. And it's up to the DPP to then decide to initiate criminal proceedings. You can provide your information, you can make your suggestions to the DPP, but at the end of the day, he is the only one who can institute or initiate criminal prosecution of that kind. So I wouldn't want to speculate on things that I don't know what the factual matrix really is.
But if during the prosecution of the civil matter, evidence is brought forward and information is revealed that indicates that there should be criminal prosecution, would not that criminal prosecution be prejudiced or hurt in any way because there has already been this exposure in terms of the civil matter being out there in the public?
Well, the only way, if it is that you didn't have sufficient information to initiate criminal proceedings in the first place, and you're saying that it comes arising out of the civil matter, then one can only imagine that that would be in a circumstance where you've had an opportunity to hear from the defendants, and they would have either given information which is self-incriminatory or, revealed further information which then led to further investigations. So at that point, you can then make a decision because it has there's precedent for it that you can actually suspend civil proceedings pending the outcome of criminal proceedings if you fear the risk of contamination. Because in such a circumstance, I agree with your point that yes, the criminal matter would take priority because once you're talking the criminal matter, you're talking liberty of the subject and you're talking people's possible constitutional rights. So therefore, you always want to safeguard that process as much as possible to ensure that you follow everything properly and you dot every I and cross every T.
Mr. George, do you think this will be a massive undertaking by the government? I mean, it's for a period of time, whether it's 5 years as the case might be. You would need people doing research. You would need a whole lot of legal and paralegal people, perhaps even foreign QCs as the case might be. Do you think they would have the resources to pursue to the end a comprehensive case against the people who they say were involved in corruption?
Well, I would imagine that if they were speaking, I mean, we just are piecing together, from the little the little smidgen of information that is out there in the public domain now. I saw reference to an audit which was ostensibly carried out into the operations of the Housing Development Corporation, and it was carried out by an internationally renowned accounting firm.
Yes.
So one would imagine that if you have that already and you have the findings of that firm in relation to that audit, and now you have litigation which flows from that, one would imagine that you already have most of your evidential basis for moving this case forward. So I don't expect that there's going to be, too much deviling or legwork that is required at this stage. In other words, the way the civil jurisdiction is now structured, you must have all your information put together and packaged properly even before you go to court. There ought to have been pre-action protocol letters that should have been sent out. So the thing is, there's a lot of information we need to get in order to be able to make a proper and constructive analysis of this scenario. But as I would say, I do applaud and appreciate the approach of not, mounting a political platform to, call out people's names and trumpet this as,
yes.
I am, exposing this one as, corrupt, that kind of thing. As I saw one of the news reports, the Attorney General said, let the court be the final arbiter of these matters. And I certainly applaud that.
who would determine who would hear a case like this? Well, a particular judge, as the case might be. Is it simply a matter of the cases have been, let's say, sent to court, and it joins a queue, or would it be given any kind of priority at all?
Well, if it's this civil jurisdiction, there's a docket system whereby cases are assigned to particular judges. It's normally a rotation system. However, the Chief Justice does have the say in terms of things that are high priority to ensure that, yes, they are fast-tracked so that, there's, less time spent lingering in the system, particularly for extremely important matters. I would imagine that this would classify as one of those, and it certainly would be given some kind of high priority.
And the thing is, if there are attendant cases, because we know that Mrs. Jolene John has taken the board of the HDC to court, as the case might be, would a judgment in that issue affect the upcoming cases that the government has, the AG has filed?
Well,
would one verdict affect the other?
Well, again, we are speaking in a vacuum because we don't know what exactly the cases are. We don't know if anything is related to her. We don't know if anything touches or impinges upon, anything that she is claiming or that she is alleged to have done. The same way the FBI director 9 days ago did not know what the new emails had, but yet still he went ahead and spoke out of turn. So the thing is, again, we can't speculate. We just simply don't know at this stage. When we get more information, we'll be able to, comprehensively answer those kinds of questions.
We've got a caller on the line. Hello, good morning. You're on the air.
Yes, Mr. George, good morning.
Hi, good morning to you, sir.
Mr. George, if the state were to get judgment against the 9 defendants in this civil matter, but then it is proven they are all men of fraud, what happens? Thank you.
Well, the thing is, one would imagine that you would also have done your background checks in terms of the movement of assets. So I don't imagine you're going to say that, look, these people, because I did see a definite reference to a multi-million-dollar claim, right? I did see that in the reported in the press. So if you're saying that persons may have illegally or corruptly obtained millions of dollars, then there are ways of tracing the trail. So even though persons may transfer the monies or transfer properties to other people's names, there are ways of tracing. You could actually apply for what is called a tracing order, from the court, to be able to trace the assets, to be able to follow the money, basically. So even though they may say, well, look, I personally do not have any assets in my name, if it is that you can then show that, look, okay, from you transferring it to this other person ends up with what is essentially the proceeds of crime or criminal activity, then the government does have the power to be able to go after the property or the asset there, wherever it is found.
Another caller. Hello, good morning. You're on the air.
Yes, Jessime again. And Mr. George, it is my view that all this is only gambage. Now, yesterday I was listening to another radio station where the director of NHA, some official of NHA, said that all these allegations made and exposed to the press are in fact not true, and that he will make a statement today countermanding that. The point is that Jessime and others have not outlined anything on the Guardian or any newspaper as such. So let us take it that the situation is real. Now, if these situations are real, the Minister of Finance and his wife are involved at a level of paying to a company monies that were owed, and invoices, I understand, were not brought forward, were not paid, were not were not identified. The point also is that the Attorney General himself has received certain sums in the consequences. Now, Mr. George, this whole situation is fishy, and I believe it's just an exercise to pull wool over the public's eye. And as Mrs. Ramjit has said, the ILP leader, these allegations may be withdrawn. These matters for the DPP. He is the person competently involved, should be involved competently to lay charges. This is just a sort of gambage and a situation of Mama Guy. That's all, Mr. George.
Your comment, Martin George.
I love the use of the colloquial in terms of gambage and mama guy, because I always find our language is so rich.
Yes, it's very descriptive.
In terms of the local parlance, I always appreciate being able to put that even in a structured formal sentence.
We will make sure that no one can accuse you of Movelang this morning.
Yes, yes. So the thing is, but on the other hand, this caller appears to have information that I don't have, that nobody in the media really seems to have, because to make that kind of definitive finding at this stage, I would be I'd be remiss if I was seeking to make any such conclusion without having the benefit of actually seeing the proceedings. So I have not seen the proceedings, so I can't make any pronouncement on them at all, in terms of referring to it as gambage or anything of the sort. So unless that caller has actually seen the proceedings and I guess has some kind of legal interpretation on them that he can determine from now that, look, they have no chance of success in terms of the litigation, then it might be a bit premature, I think, to make those conclusions.
We have 7:55.5. That's our time here. That time check brought to you by Demas Solutions. And I just want to squeeze in a couple more calls before we let you go, Martin George. Hello, good morning. You're on the air. Hello? Okay.
Hello.
Yes, you need to be really quick, please.
Yes, I thought this matter where they talking about the agency is a smooth clean thing.
Okay.
Long time they should call in the front court first of all and see documents, and then the documents is to prove the case in the court. But that is a smoke screen. There are nothing in it, and up to now they call nobody name who involved in the matter.
All right, thank you, caller. And I think most people are concerned with the fact that they have not heard any names being called. But it is important not to call the names ahead of time before the case starts in order to preserve the integrity of what's being done. Not so, Martin George.
But as I said, Jesse, you see, no, the thing is, what I would say, it's important not to politicize the matter. But I think actually the names ought to be made public, quite frankly, if it is that you're talking civil litigation, because as I said, at the end of the day, these are matters of public record, and once you're talking about the government using taxpayers' money to go after individuals in this way, then I think there ought to be some level of disclosure without sensationalizing and politicizing the issue. I think there's a happy medium you can strike, whereby you either just issue a very short statement. Look, High Court proceedings number so have been initiated against, A, B, C, D, E. The claim is for this amount of money in relation to activities at HDC. And you leave it there, if you understand me. The individuals would have received their documents, would have received their papers, so they would know all the nitty-gritty details. But at the end of the day, the public is not left to wonder, you see. And I think this is where it fuels the suspicion. And, because the point is, I guess we've been so jaded and tired of politicians playing games with us that we are very wary and, suspicious of anything that, looks like there's a veil of secrecy. We feel that someone is hiding something. And it may not necessarily be the case at all. It may just be a case of trying to be overly circumspect. And I don't think we need to go that far in terms of not revealing the names. And I think the public pressure is going to mount, and the government will eventually have to reveal the names. Or, as I said, persons can go to the civil registry and make a request in relation to the matter and ask for copies of the documents.
Can they really avoid pretrial publicity, negative pretrial publicity?
Well, the thing is, Jesse, pretrial publicity is such an abused and overused term in Trinidad and Tobago, and I think most people don't even begin to understand what it involves. First and foremost, in relation to a civil matter, it really has little or no place whatsoever. Because in our jurisdiction, the only arbiter of the facts and the law is the judge. So unless you are suggesting that the judge has been affected by things the judge would have seen in the media or in the news and has therefore formed preconceived notions which will essentially deny one party fundamentally any prospect of getting justice. And it's a very high bar you have to set in terms of trying to establish that kind of thing. It really doesn't apply basically in civil proceedings. It more applies in terms of criminal matters. And even there, if we recall the case of Basdeo Pandey versus Magistrate Ejeni Espinay, you recall in the matter where Mr. Pandey and his one of his several matters, he appeared before Magistrate Ejeni Espinay, and he was claiming the issue of bias. And he was saying that, look, the magistrate would be biased against him because the magistrate was her father was a member of a group within the PNM organization. And he was then saying that the charges against him were politically motivated, and thus he would suffer, because of that bias. And that matter was determined, and the Court of Appeal held that, look, no, not simply because there is this connection means automatically that the person presiding is going to be biased against you.
We have to leave it there.
Show bias.
We have to leave it there, but thank you so much.
Always a pleasure.
Thank you, Martin.
This is news on Sky 99.